how trustees evaluate you. We're here with Larry Friedman. We're going to get inside information, really good information that every bankruptcy attorney should know. Larry Friedman, former director of the U.S. Trustee Program. Good to see you, Larry.
Good to see you, Phil.
Knowing what you know about the trustee program, if you were going to start a practice today or had an active practice today, like what are the one, two, and three things that every bankruptcy attorney who's watching this, who will watch this, should have on their radar screen? Like, as the head, you just understand the nuances that a lot of us in the trenches just don't even think about. So
Mhm.
what would those like must know things as someone who ran the program?
You should be aware that your case trustee was appointed by the U.S. Trustee Program. And actually, in a Chapter 7 case and a Chapter 50 case, when they conduct those 341 hearings and confirmation hearings in a 13, they're doing so as the representative of the U.S. Trustee Program.
Mhm.
So it's as if there's a government employee there doing it, but they've delegated that responsibility to private trustees. So you should be aware that there is this bigger structure out there.
Mhm.
And people go into a bankruptcy 341 hearing and all they care about is, is the debtor going to get their discharge? Do they
Mhm.
fill this out right? Whatever. They need to understand that there might be other things with regard to compliance that raise flags that get passed up to the program. A lot of times, the case trustees, let's say in a Chapter 7 case, they're interested in one thing. Well, two things, three things maybe. They're interested that the debtor's entitled to get a discharge because they have a statutory obligation to object to the debtor's discharge if there's cause, because the debtor lied or hid an asset or something like that. So they're interested in that, but they're most interested in, the debtor getting his discharge, in this case, getting through the system. And it is, for the most part, an administrative process. So
Right.
if you build your practice in a way that is compliant and locked down for something like an administrative practice,
Mhm.
that's the biggest thing you can do to avoid problems.
Right.
Because problems occur for your client when they tell you something at the 341 hearing. And my opening question always was, look, you and I were both born, naked and innocent. You ended up on that side of the table. I ended up on this side of the table. I want to understand what happened. I'm not here to judge you on your life choices or things that happened in your life, but I want to understand it. And that would get debtors talking. And then as they were talking, I would look at the schedules. And if the schedules made sense and seemed to track the story I was hearing, I was good.
Right.
Oftentimes they didn't though. Like
But I mean,
debtors,
do you really, I mean, but do bankruptcy attorneys really not? I mean, I can't imagine like the debt attorneys I think about. I mean, they're not fabricating things. They're taking the information that the debtor says it's
yeah.
broken, they're doing, but I don't, I mean, clearly there's a small minority of the people that are
Right.
fraudulently
We're talking about sloppy practices,
sloppy
things that
practice.
trip you up because of
Yeah, right.
sloppy practices,
So,
not
but
because
when you, let's going back to your first point of being aware of like, a bigger brother overseeing things so you can't be being aware not to be sloppy. I'm just trying to fine tune this a little bit.
yeah. So for example, the software out there is very good these days. You interview a debtor, your paralegal interviews the debtor, you have an outside paralegal that interviews the debtor. They put the information into the software generates a set of
Right.
schedules. But let's say that for whatever reason, you didn't list the debtor's bank account.
Hmm.
Maybe the debtor doesn't have a bank account. I mean, people are real poor
Hmm.
sometimes, right?
Right.
But but if they're working and they don't have a bank account, that doesn't make sense because it leads to questions like, well, how do you get paid? You don't get paid in cash. You get paid by
Right.
check. What do you do with the check? I
Hmm.
deposit my bank. Oh, where? What bank account? It's not listed.
Yeah.
Little things like that.
Yeah.
I had
The
one
sloppy.
yesterday.
Yeah, that's
I had
okay.
one yesterday, Phil. We were looking at a redemption deal, and the car was listed at value having a value of $32,000 on Schedule C exemptions with $4,000, $4,400 of an exemption.
Hmm.
But on Schedule B, the car was listed as there was a claim, $54,000 claim by the
Hmm.
secured creditor, and the valuation was $34,000. So
Got it. Yeah.
clearly there's negative equity in the car.
Hmm.
Why does one schedule show equity and the other one not show
Yeah.
equity?
Okay.
The
Fair enough.
software's not perfect.
Fair enough. So I think the point of the first thing, if you're from the voice of the former director of the U.S. Trustee Program, don't be sloppy. What's the second point?
Well, the
What
second
else do
thing
the
is what
bankruptcy attorneys need to know?
they need to listen to their client and ask probative questions.
Hmm.
So, why are you filing bankruptcy? Well, I've been out of work for 6 months.
Hmm.
And are you looking for work? Well, no, my back hurts and I'm going to these doctors. But they never maybe ask, well, how were you injured?
Hmm.
Oh, I was in a car accident. Oh, do you have an attorney representing? Oh, yeah, that's my PI case. Yeah, I didn't do
Yeah.
it. Easy for that case not to get listed because they just didn't ask the right question.
Right.
Again, no malfeasance on
Mhm.
behalf of either the debtor
Yeah.
or the attorney. The debtor didn't know he had to list it, and the attorney didn't ask enough probing
Okay,
questions.
let me ask you a question. What percentage of the of the debtor attorney community is would do something like that? What do
Well,
you think? I mean, I'm
I
talking gut feel, because I just can't imagine a 720 system strategies attorney dropping that ball. Like I don't know, but maybe not. What I mean, are we talking like,
it's look, it's hard to say. I would say this. Let's say that in Chapter 7, 92% of the cases are no asset cases.
mhm,
Can we agree on that? Right?
mhm,
I would say of the 8% that are asset cases, a high percentage of those are asset cases because of things like this.
mhm,
Now it can be more subtle, Phil. So the very best attorneys can miss this. The debtor has been out of work and trying to, beg, borrow, and get money from anywhere they can to pay their bills every month.
right,
And people help them out, right? Family members help them out,
right, of course,
friends help them out, whatever. If someone has helped you out and you feel an obligation to want to pay them back, of course,
mhm,
and then you're about to file bankruptcy, and so you're like, oh, listen, it's I borrowed a couple $1,000. I'm going to file this bankruptcy case, and by the way, here's the $2,000 back that I borrowed because I don't
right,
want you
yeah,
getting
right,
stuck
yeah,
for bank.
yeah,
Well, that's a preference claim.
yeah, right, yep,
And those kind of things can fall into the cracks.
right,
And then the trustee discovers the preference claim,
right,
right? They might look at a bank statement, they might see a check was written. And now all of a sudden, the person you were trying to protect, who you just paid $2,000 for, is subject to an action by the trustee to recover the $2,000.
yeah. We've talked a lot on these calls about not doing unsupervised forms, right? So we many times these debtor attorneys have these forms where people go through. Have you ever done this? Have you paid anybody? Have you, whatever it is, right? Looking for that yes in the litany of no's. And we've talked about, hey, the problem with those big unsupervised forms, they slow down the debtor. They're unsophisticated debtors. The debtors are like, they don't fill it out. And I think your point of this whole thing, and it's something I did not have thought of before, is there's a value to the unsupervised forms that root out these unneeded things. And I mean, there'd be easy ways to do it where they're not in physical form where you're printing and copying, but it's a click, it's a link, it's a type form where it's all automated, it goes through very, 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 very fast. And that's what you're talking about, right?
Yeah. And the point is, don't forget to talk to the debtor, have a colloquy with the debtor, a
Yeah,
conversation with the debtor,
yeah,
understand why, do the best you can to understand why the debtor is in the situation they're in. And then as you go through these very detailed processes, the flags will pop up
right.
automatically. It's like, well,
Well, one of the things you talked about on a previous call that I really appreciated, because the nice thing about being a debtor attorney, it's a transactional based firm, right? You don't have to deal with the emotions of a family law or the nuances of criminal or whatever it is. It's very transactional based. And you were like talking about some of the best firms that you remember when you were director, or these process focused firms, right?
yeah,
Because that's
yeah.
how you really just can grow the practice because it's transactional at a next level. Can you speak into that?
Going back to this, perception from the early 90s with debtor firms, there were a lot of negative perceptions. And part of what I was tasked with doing was looking at the system and saying, where are the real problems? There was a lot of flipping houses. People filed bankruptcy on a piece of property, then they deed the property to somebody else. They'd file a bankruptcy, and there was ways to push off, liens on bankruptcy, stop foreclosure sales. There were all these A lot of it, unfortunately, out west, beautiful state of California, was out there, but it gave debtor attorneys a negative connotation on some of that stuff. And so we went out and looked at it. The very first thing I did is we went out and looked at some debtor firms that we knew were very good, and we looked at some trustee firms that were very, very good. And contrary to the perception that this was high volume practices and people pushing people into these processes that were questionable, the big process driven firms were the best at it.
Yeah.
They were very, very good. Why? Because you can't handle that kind of volume without understanding it's a business that needs business processes that are locked down, audited, both scalable and audible, so that so they can be transparent. It was in fact the guys filing a few cases a month who were sloppy. It was the ones who were, I'm just helping a few people out, that were sloppy. That was probably the biggest revelation first when I first got there and started looking at this issue.
There's a lot of disadvantages of our very unique niche in consumer debtors and bankruptcies, but this is a huge advantage of it. And with the complexity of bankruptcy law now, it's not like it was 20 years ago,
It
right?
is very, very different since BEPSIPA.
And it's not as if people can just jump in. We
Right.
see it all the time. I mean, we people call us up and they're like, "Oh, I want to get in the bankruptcy business," and I'm like, "Okay, here we go," because there's a huge learning curve, right?
Yes.
And it's something that is greatly underappreciated because back then, when the run up of bankruptcies would go up and down, you would get a lot more of this in and out, which is we're not seeing it like we used to. So, okay,
Well,
Larry.
there are problems with that. So yeah, go
Yeah.
ahead.
Okay. Okay. Going back to sloppiness, is there anything else other than being sloppy that you'd be? We got sloppiness. We got process.
I think those are the two buckets I would put
Yeah.
things in.
Yeah. Great. So sloppiness and process, and those are things that are easily fixed. I mean, we talked about the forms online. Definitely go online with that. With regard to the processes, there's a lot of great software out there. Larry, thank you for your time. Thank you for your interest, and thanks for all you've given to the bankruptcy debtor community. And we will do more.
Love to. Thanks so
Thanks,
much,
Larry.
Phil.
Thanks,
Appreciate it.
everybody.